Good afternoon, Miss Bridgewater or Miss Strong.
Good afternoon. How are you?
I'm good. How are you?
Good, good. Long time no see.
Yes, I know. So I see that Union City is on, and I have not been able to interview. I have two clients at Union City.
Okay, Miss
Yes, I
Strong,
see.
it's gonna be the Zoom czar today. So if you would just let her know who they are and perhaps she could do a breakout and so we can move on with the cases.
Okay, thank you.
So you want to go ahead and announce them?
Yes, I need to interview position 5, Curtis Cofield at Union City, and position 7, London Farley, who's also at Union City.
Okay. Um, I don't know whether she heard you, but I will pass the message on.
I can send her a chat too.
Thank you. That would be
Y'all
great.
talking to me?
Yes,
Yes.
Oh, I'm sorry. I thought y'all were talking about Judge Mancy. You want to go into a breakout room with who?
with South Annex.
Okay, give me 1 second.
Hey, McLean,
Mm-hmm.
position number 14, Mr. Trimble, that's gonna be a medical reset. They just,
Oh.
they put him on SOS immediately.
How's it looking for Mr. Wise, W-I-S-E?
I can't hear you. You break it up.
He said he's gonna post his bond, he has a power of attorney, he's gonna post his bond, so the attorney was supposed to represent him today, but he has another case in another jurisdiction, so he's gonna go ahead and post his bond.
You heard that, Mike?
No, it was breaking up. Is that regarding Wise? He has a private attorney or something else?
Yes, so his bond is, posted.
Oh, he's already posted bond. Okay, gotcha.
Which position was this?
The last one?
Okay. And also 14 is a medical reset?
That's correct.
Thank you.
Court's in session.
Good afternoon, everyone. We're ready to start.
Good afternoon, Dave.
All right. Good afternoon, everyone. I am Judge Regina Mincy. We're going to begin our Fulton County State Court Expedited Accusations calendar. This is a calendar for cases in which individuals have recently been arrested and charged with certain misdemeanor offenses. Soon after their arrest, the Fulton County Solicitor General has already accused the cases of the offenses brought against them, and the cases have been bound over to the Fulton County State Court. Nevertheless, this will usually be the defendant's initial appearance before a state court judge, so we are able to address several matters, including bond, possible arraignment, and a possible plea offer if one has been made by the state at this juncture. I want to begin by reminding everyone that this whole entire proceeding is being recorded as well as live streamed on YouTube, so govern yourselves accordingly. I want to also remind the defendants on this calendar that you have certain constitutional rights. The first being that you have a right to counsel. You should know who your attorneys are by now and have spoken to them. Also want to let you know that you do have a right to remain silent. Anything that you state about the facts and circumstances or the occurrences in your case can and will be held against you. The state is here and they're listening. So again, listen to your attorneys. I think I heard as I was coming on, position 14 is a medical reset.
That is correct.
And then what are the other announcements?
18 posted bond.
Okay, 18. All right,
And also, Your Honor, if I may, the reset date for the SAP calendar is December the 19th.
okay. December 19th. Yeah, forgot to say that.
That's okay.
And Your
All
Honor,
right.
also
Yes, sir.
Position number 9 posted bond.
Oh, okay.
Good. 9. Okay.
That's correct.
And I think I did hear PD Atai say that she had to interview 2 people, so we're doing that, correct?
That's correct. She's in the breakout.
Thank you. Anything else?
But we're gonna start with position number 10. And this
Okay.
is Norman Monroe. He has private counsel.
I think I see him sitting there next to him. Tell me your name, sir.
Yes, Your Honor. Good afternoon. I'm Attorney Durante Partridge, Judge.
Okay. All right, this is 24 CR 00797-1D. This is Norman Monroe. He's charged with 1 count of battery and a 2nd count of simple battery. Pre-trial?
Can you hear me?
Yes.
26. Got an open case in Superior Court, 24 SC 003401. Sale of marijuana, failure to obey traffic light, failure to maintain insurance, expired or no registration. Probation violations from 2022, 2023, 2021, 2019, ag assault conviction, probation from 2018, FTA from 2017. That's it.
All right. State.
Thank you, Your Honor. That's my case.
Okay.
This is an incident that happened on June the 20th. The victim is a stranger to the defendant, and I believe it took a period of time to identify him. Police were called to 3179 Peachtree Road. This is a club. The victim, her name is Alexandria Love, reported that she'd been struck while outside the location by the defendant multiple times with fists to the face. He pushed her to the ground as well, causing abrasions and scratches on her arms. She reported she'd had a verbal argument. The defendant was with a woman. She was accused of breaking in line, I believe. They were upset with her. They thought she broke in line. He then aggressively shoved her to the ground and punched her. This was captured on cell phone video, which someone posted onto social media. Individuals on social media responded and identified the defendant eventually. Police officers reviewed his information, saw that he had a recent arrest for assault at the Red Martini Bar. The victim provided a recorded statement, and she ended up picking him out of a photo lineup, Your Honor, and arrest warrant was issued. We've spoken with the victim today. She corroborated she does not know the defendant. She verified the information that is in the documentation and warrants. She reports the defendant followed her and pushed her. She had a black eye as a result of this. And she also said that she suffered a dislocated disc in her neck and continues physical therapy. So this could be upgraded to a felony with some documentation about a medical issue. She'd asked for no contact, Your Honor, and that seems appropriate based on the fact that this defendant has a prior aggravated assault and false imprisonment conviction, as well as looks like two or three prior arrests for stalking, battery, and aggravated assault. We're asking for a $4,000 surety, no contact with Miss Love, and no drugs, alcohol, or weapons. He's currently in violation of the bond that he's out on in that 24 SC case, Your Honor. Thank
All
you.
right. Okay. All right, Attorney Partridge.
Yes, Judge, thank you so much for the opportunity to speak on behalf of Mr. Monroe. Judge, when this incident happened, Mr. Monroe actually called me the evening of that incident to advise me as to what took place. Judge, since then, I've spoken to several witnesses, including employees of the establishment that is now closed. I also spoke with APD officers that were there that witnessed this. as well. In addition to that, Judge, there were several witnesses with my client. They all account that this was a self-defense issue. I know that we'll call balls and strikes as it relates to self-defense at a later time, Judge, but nonetheless wanted to make sure that I pointed that out. This incident was captured on video. An edited copy of that video was posted online. We do and are in the process of getting the full video as it relates to this, Judge. But this is a situation, again, that happened mere feet in front of police officers, APD officers that were there as security for that particular establishment. And essentially what happened was the victim, Miss Love, or the complaining witness, Miss Love, in this situation, essentially spat on Mr. Monroe. She struck Mr. Monroe, and he did nothing. He was advised by police to leave. And as he's starting to leave, this, again, complaining witness, Miss Love, runs to try to attack him, and he defended himself in that situation, Your Honor. That is the account of at least 6 people that were out at the nightclub that night who are willing to testify that Miss Love was under the influence, that she and her friend were trying to fight not only Mr. Monroe, but other women that he was with that particular evening. He does not know Miss Love at all, and was in a position where he unfortunately had to defend himself in this situation. He's a much bigger man than that of Miss Love. So this was not a fight that he picked and tried to beat this young lady up or anything along those lines, Judge. I'd submit to the court as well that Mr. Monroe took a plea to the aggravated assault, an Alford plea first and foremost, Judge, but he took the plea because he spent 3 years in Fulton County Jail during that of COVID, and was not granted a bond and was denied bond at least on 6 different occasions by Judge Dunaway and other judges along the way, Judge. So unfortunately, it was a situation where he had the opportunity to get out of jail, and he took a plea, an Alford plea, not admitting guilt as it relates to that, but did take a plea because it was in his best interest to do so and his best interest to go home. Judge, nonetheless, we have discovery that we are compiling to get over to the state. We would ask the court to, if the court would consider a signature bond or UJR with regard to Mr. Monroe. We've talked to the DA's office with regard to this case as well. We did not know that there was a warrant outstanding, again, because the officers did not arrest Mr. Monroe when this physical altercation took place in front of them. And it was later that Miss Love went to an APD officer that was not there, that did not properly investigate, did not talk to those officers that were there, and crafted this warrant, basically, Your Honor. So that was the case as it relates to that. I will also add that Miss Love has gone through several lengths with figuring out Mr. Monroe's identity to try to extort him as well for money, for financial gain. So we will compile all of that evidence, get it over to the state at the appropriate time, Your Honor. But we are asking the court to set a reasonable bond, if not a signature bond, on behalf of Mr. Monroe. I would ask the court to set a $2,000 bond.
And Your Honor, just briefly, Miss Love is on the Zoom, so if you'd sound for her. An Alford plea is a psychological thing. This defendant pled guilty to an aggravated assault. An Alford plea doesn't undo that.
Okay.
Doesn't say anything like that on the records, like, just kidding, this isn't real. And he is out on bond for a felony possession with intent. So if you would sound for Mrs. Love, thank you.
And
If
I
I may, Your
apologize.
Honor.
I should have sounded for Miss Love. I'm sorry.
If I may, Your Honor.
And you
My
are?
name's Asia Lewis. I'm with
Okay.
Durham Law Group. I represent Miss Love for the personal injury claim that she's currently pursuing as it relates to her injuries from this matter. And we were just requested to be here to provide some insight as to her injuries and her medical treatment and costs and things of that nature, if such information is still being requested.
No, it's not being requested by me as the judge, because I am here. This is a bond hearing. This is not the trial. And I was gracious to Attorney Partridge by letting him get into some of the facts a little bit. But the Ayala factors that I'm weighing don't go as strongly or heavily toward the facts and self-defense and all that. But I do listen, but I'm certainly wanted to first give the victim a chance to speak briefly if she wanted to. The state has spoken to her and given me a synopsis of her desires for this bond. And I don't want to get into the personal injury side or that, that is not my purview right now.
Understand.
Where is Miss Love? Is she there with you or she's on another? Miss
No,
Love?
she's also virtual.
She's virtual. I
Yes,
don't
ma'am.
see anybody with that name. I see an iPhone or two. Miss Love? Alexandria Love, are you on the Zoom?
Yes, I am here.
All right. Do you wish to address the court today? Yes or
Yes,
no?
yes, I will.
If you do, you need to turn on your camera and I'm going to have to swear you in first.
Hello.
Okay. All right. Raise your right hand for me. Do you affirm that the
Alright.
testimony you're about to give is the truth and nothing but the truth
Yes,
under the penalty of perjury?
yes.
All right. As I stated, and I guess you just heard me, this is not the trial. This is a bond hearing. And so the two questions I have for you is, do you want to
Yeah.
have any contact with Mr. Monroe?
No, I would not.
You can put your hand down.
No, I
And
would not.
are you in fear of Mr. Monroe?
Yes, I am. He threatened me in my life on the
Okay.
video.
Okay. All right. And that's all I have. State, do you have any questions?
No, Your Honor.
Attorney Partridge, do you have any questions?
Not at this time, Your Honor.
Okay. All right. And so, I believe what concerns me most, obviously, is the history of the defendant and whether he's going to show back up in court and will we be able to find him? And I know he has you, Attorney Partridge, and you'll keep him on the straight and narrow, but his history is just not great at all. So I'm certainly not going to give him a signature bond. And with the open Superior Court case and the violations of that bond, I'm not giving him a signature bond. I'm going to order the $4,000 surety bond, which will be $2,000 on each of the charges. And with that $4,000 surety bond, he is to have no further contact with Alexandria Love. He's got to stay 2 football fields away from her. And I'm going to say this, and I say it a lot, and there's to be no more posting about this case on social media, Instagram, Facebook, and some of the other sites that I'm not even aware of. But there will be no more posting by anybody, no witnesses, no friends, and certainly not the defendant and certainly not the victim. So let's get this off of social media and stop talking about it. Don't upload any more videos, pictures, or anything. And that is to all parties involved. And no drugs, alcohol, weapons, or guns while on bond. And guess I don't need to say stay away from the incident location because it's closed down anyway. Anything else that I've left out, counsel, on either side, or anything I need to address?
No, Your Honor, not from the defense.
No, thank
All
you.
right. Okay. All right. That is it. Do you have any more cases, Attorney Partridge?
No, Judge, that was my only one. May I be excused?
We will let you out of jail. Yes, you may.
you,
All right. You're welcome. All right. Take care.
Good to see you, Miss Allen.
Okay. Yes. And thank you, Ms. Lewis. I don't want to be rude to you, and I appreciate you getting on. And you'll just listen out for the next hearing. Okay.
Yeah.
All right.
Yes, Your Honor. Thank you. Y'all have
Thank
a good
you.
one.
You too. Thank you. And Miss Love, you're free to go too. Thank you.
Judge, before we proceed, Ms.
Yes.
Ty is asking for a breakout room for 5 and 7. So courtroom 2, where are 5 and 7? Since Ms. Ty is requesting a breakout room.
They are at South Annex.
Both of those?
Both?
Yes,
You already spoke to them, right, Mr. Ty?
yes,
You spoke to both of them already?
I did.
Oh,
Okay.
but you still want to break out for the hearing though?
Yes.
Okay. Okay.
Oh, I'm sorry. I thought you meant now. Okay. My apologies.
Yeah. Who do we have
Um,
next, Deputy?
This is gonna be position number 15, Mr. Jonathan Waldrop.
Okay. This is 24 CR 007966F. Jonathan Waldrop, charged at 1 count of battery, pretrial.
46. 2023 terrorist threats, probation, conviction. 2023 simple assault conviction. 2022, he got 3 trespass convictions from 2022. One of them had a shoplifting to go with it. 2022 FTA, 2021 FTA, 2021 trespass conviction, 2021 probation, 2020 battery conviction, 2020 FTA, 2020 obstruction conviction, 2020 reckless conduct conviction, and 2012 trespass conviction.
All right, State.
Thank you, Your Honor. Your Honor, this is an assault on a stranger. First of all, it's an incident from January of 2024, I believe. Let me make sure.
Says November on the calendar.
Then I just forgot another one. November the 22nd, I believe, 2024.
Yes.
This is a Chick-fil-A at 7810 Sonoya Road in Fairburn. So right before noon on that day, Kyle Simmons, a employee at the location, behind the counter, engaged with the defendant who requested free food. And when he was told no by the employee, the defendant in front of you walked around the counter and proceeded to strike the employee in the face multiple times. This was captured on security camera. Other employees were present and provided statements to police. It's reported that they had never encountered this gentleman before. We've been in touch with the victim, Your Honor. He's unable to attend Zoom. He's working. He's the manager of that location, the Chick-fil-A. He reports that before the defendant walked around the counter, he began cursing at the victim, and he ended up with bruises on his legs and on his face. He is requesting a stay away, and that seems appropriate. This defendant has multiple convictions out of Georgia and California that include felonies, many convictions for arson, harassment, DUI, burglary, reckless conduct, battery, simple assault. And the fact that this is an assault on a stranger is particularly concerning, Your Honor. We'd ask for a $2,000 surety, a stay away from that location, the Chick-fil-A at 7810 Sonoya Road. No contact with the victim, Mr. Simmons, Kyle, K-Y-L-E. And we'd also request no drugs, alcohol, and weapons, and a social worker visit, Your Honor. Thank you.
And a social worker visit?
It seems like that might be appropriate, yes.
Okay.
Or a mental health evaluation.
All right. Is this Mr. McLean, PD McLean?
There, very good. Yes, Your Honor, my client is 40 years old. He does have the arrest record that has been spoken of. Your Honor, he himself has worked as a server and a cook in quite a few different restaurants in the last 5 years and more. He's been in Georgia for 37 years. He's 40. So basically, he's local. He's a Georgian now, although he has been elsewhere. We would ask the court to consider the lowest possible bond, including a signature bond if that's possible. If the court's not leaning towards that, we would ask for $1,000 surety. That's the kind the bonding companies would touch.
All right. And we don't have, you stated the victim was not on. Just remember that. All right. I'm going to order the $2,000 surety bond. With that surety bond, again, is to stay away from the Chick-fil-A on Sonoya Road in Fairburn. I dare say all Chick-fil-A's, but certainly if he can't go into any restaurants without being accused of assaulting anyone, he shouldn't go in any of them. But certainly not the one that's the incident for this location. Also, no further contact with the victim, Kyle Simmons. No drugs, alcohol, weapons, or guns while on bond. And I'm going to order the social worker visit. I'm assuming, Mr. McLean, do you not think he needs mental health eval or not?
Well, our social worker can determine whether she would recommend a BHE or nothing at all, but that'll be Natasha Ammon Williams, and I've talked to her about my calendar. So we're going to get together as soon as my calendar is over with, and I'll give her a list of the people that we need to have social work visits on.
Okay. All right. That'll be it, I believe.
Thanks.
Mm-hmm.
Next, Your Honor, we're gonna go to positions 1 and position 2, Mr. Abdul Rabani.
All right. First case is 24 CR 007955J. Mr. Abdul Rabani, charged with 1 count of simple battery against a person who is 65 years or older, or who is pregnant at the time of that offense from May 3rd, 2024. And the second case is 24 CR 00795561. And that's the same charge, simple battery against an elderly or pregnant person from July 1, 2024. Are these the same victims?
Yes, Your Honor.
Okay. All right. Pre-trial?
6 total. They've been in custody since November 23rd. Felony stuff. Got to open obstruction in state court. Excuse me. Got to open theft by deception, discharge of a firearm near public highway, reckless conduct, unlawful carrying a weapon out of state court as well. His last arrest was in Miami. Possession of marijuana, more than 20 grams, false ID, and a 2023 FTA. That's it.
Okay. State?
Yes, Your Honor. The victim in both cases is Miss Kindley Lofton, who was living with the defendant at the time of the incident. She is now has now had their child, who is 2 weeks old at this time. The first incident happened May 3rd, 2024 at 48 Peachtree Avenue Northwest in Atlanta. The victim and the defendant were having a dispute because the victim wanted the defendant to leave the apartment and she had placed his belongings outside. The defendant then tried to re-enter the apartment through a broken window and was attempting to unlock the front door through that window. The victim did try to prevent him from doing so, and the defendant ended up picking up an LED light and swinging it around, striking the victim with it. The defendant fled when the victim called the police. The second incident happened July 1st of 2024. The parties were having an argument at the parking lot of the gas station located at 3580 Campbellton Road Southwest when the defendant pulled the victim's hair. Our office has had a chance to speak with the victim in this case, who states that her and the defendant were in a relationship. They don't live together currently, and they do, of course, share that 1 2-week-old child. She confirmed the events in both of the warrants. She states that she no longer lives at the 48 Peachtree Avenue address. She states that she has since moved and she currently lives at 3129 Candlewood Drive Southwest. She states that on October 15th, the defendant vandalized her apartment and that the defendant has been calling and harassing her since that October 15th incident. She says that the defendant has been calling her since he's been in jail. She, of course, wants no contact and wants the defendant to stay away from her entire apartment complex. Our office has looked into the jail calls and we see that the defendant has called the victim from the jail over 60 times. So there is a concern that he will intimidate this witness as he has assaulted her on 2 occasions that we know of. And he has also called her upwards of 6 dozen times since he's been in jail. We do see that he has been in jail since November 23rd, but as pretrial stated, those were on some felony charges that he had. Per the jail screen, it looks like he's been held on these current charges only since December 4th of 2024. So it's our position that this is not a Riverside issue as he has only recently been held on these current charges that are before us today. The state's recommendation is a $2,000 surety bond on each charge, no further contact with the victim, stay away from her current address, that he do an FBIP, no drugs, weapons, or alcohol while out on bond. I would ask the court to sound for the victim in these cases, Ms. Kindley Lofton. You're on mute, Your Honor.
Sorry about that. Kimberly Lofton? Are
Kindley
you
Lofton.
with us?
Yes.
Where are you?
Okay.
Okay, it says Kinley.
Yes.
Oh, is your name Kinley and not Kimberly?
It's Kinley, Kinley.
Oh, I apologize. I think I was thinking she was saying Kimberly. All right. And last name is Lofton?
Yes.
Spell that?
LOF as in Frank, TON.
Okay, Lofton. All right, do you wish to address the court today, yes or no?
I guess so.
You do? All right, and if you do, I'm gonna swear you in, so raise your right hand for me. Do you affirm that the testimony
You're breaking up. I can't hear you.
She's not talking anymore. Just hold on a second. It's her service. Just hold on 1 second.
Okay, so she said she about to get on from her phone.
Okay.
I apologize. I didn't realize it was me. I think, and not everyone else frozen. Can everyone hear me now?
Yes.
Yes, we can
Yes,
hear.
loud and clear.
Thank you. All right. I apologize, Miss Lofton. Where are you?
I'm here.
Turn on your camera, please. Can't talk to you. They can't see you.
Okay.
All right. I was in the middle of swearing you in, and let me do that again for the record. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
Okay. All right. And put your hand down. And so I have two questions for you. The first one being, are you in fear of Mr. Abdur Rabbani?
To an extent, yes.
And do you want to have any further contact with him while this case is going on or while it's gone by?
No.
Okay. All right. And I don't have any other questions. State, do you have any?
No, Your Honor.
And PD, a tie?
No, Your Honor.
All right. And you all don't live together, is that correct?
No.
Okay. All right, you can mute yourself and continue to listen to the proceedings. All right, PD Atai.
Thank you, Your Honor. My client is 21 years old. He has lived in Georgia all his life. He is a high school graduate. He graduated from an online school during COVID. He does deny the allegations as stated in the warrant. As you heard, he was actually arrested on November 21st in East Point, and he was booked in at Fulton County on November 23rd. So it is our position that it is a Riverside issue. Although he was arrested with other charges, but these are cases from May of 2024 and July of 2024. So he should have had a first appearance on those within 3 days after November 23rd, and he did not. It's now December 5th, and he's having his first hearing today. So, but he does not have a bond on the other cases. I would ask for a signature bond in this case because it is a Riverside issue.
Well, Your Honor, I
Stay.
would just like to
Oh.
state again that if you look at the charging screen in the jail screen, you can see that he's been held on these charges only since December 4th of 2024, and he does currently have a $23,000 active bond.
All right. PD Atai, you didn't know he has a 23,000 bond?
No, Your Honor, I guess it was set this morning from what I saw this morning, I guess before he went for another felony first appearance. He had no bond on the charges. But so Your Honor, if he already has a $23,000 bond on those cases, I would ask for a signature bond. Even if it's through pretrial services, we don't object to the no further contact with the complaining witness.
Well, but you're asking for just a signature bond, but it's not because of Riverside, because there is no Riverside issue.
Well, I do think that it is a Riverside issue. He was booked in to Fulton County on November 23rd, so they should have found any outstanding warrants at that time. And he should have had a first appearance on those.
That's not Riverside, but I
Right.
appreciate the argument. If we can maybe connect with the jail staff and maybe booking and confirm that those warrants were served on the 4th of December, like it says in the system, that would be helpful.
Deputy? In courtroom 2.
What are you asking for, Ms. Allen?
Can you confirm in the jailing screen in the system, it says that these warrants on these two cases were served or issued on December the 4th?
They were.
Okay, so he hasn't been sitting in jail since November on these charges. He wasn't appraised of these charges and he wasn't served with a warrant for these charges until the 4th of December. It's very clear in the system.
You're correct.
Thank you.
Okay, thank you. All right, and I guess you can instruct your client, PD Atai, to put his hand down.
Yes, Your Honor, and I am looking now. He actually does have no bond. So he has no bond on some of the 24 PI 88.
Again, not my cases, the 24 CR, these cases that are before me right now. That's what I'm concerned about. So anyway, let me go ahead and give my ruling if there's nothing else to add. On the first case ending in 7955J, a $2,000 surety bond. And with that surety bond, he is to stay away from the residence and job or employment of Miss Kinley Lofton. Well, I'll tell you if he doesn't want to listen.
Your Honor, we're gonna take him out. What's
Okay.
gonna be the bond?
It's gonna be $2,000 surety on each case.
Thank you.
All right, thank you.
Okay.
And I will also add for the record that he is to stay away from Kinley Lofton Have no further contact from her. Stay away from her home address and her work address. Wherever she may be, he's to be 200 yards away from her. And I know they just had a baby, but right now, he's to have no contact with her, and I imagine with the child at this point. No drugs, alcohol, weapons, or guns while on bond. And that's 2,000 on each case, same conditions. All right, next.
Your Honor, we're gonna go to ACDC.
Okay,
Good afternoon, Judge. This is gonna be position number 12, Ms. Ruff.
okay.
That's Ms. McLeod's case.
I'm sorry.
This is position number 12, Ms. Ruff, and this is Ms. McLeod's case.
Oh, okay. I think I saw her. Ms. McLeod? She is signed on.
Yes, I'll give her a call because she.
Yes, Your Honor, I'm on. I'm on.
I got you. I thought I saw you. There you go. All right. This is 24 CR 007972C. Janice Ruff, charged with 1 count of terroristic threats and acts. Pre-trial?
Let's see. 48, 2019 battery, 2013 ag assault decline, 2011 simple battery DV NOD.
All right.
Your Honor, that's my case. This defendant, Mrs. Janice Ruff, also has a bunch of AKAs, including Janice Cassandra and Angela Sushon. She's got arrest history since 1981 that includes a felony conviction. I did reach out to the DA's office today because it's alleged in this case that she was in possession of a firearm. I have not heard back yet. This is an incident that occurred on December the 4th. So yesterday at about 2 in the morning at 532 Cleveland Avenue Southwest. The victim is Anthony Levy, or Ivy, excuse me, Ivey. He had recorded on video as the defendant threatened to shoot him in his head with her firearm. She had a firearm in her waistband at the time that she keeps there. We'd be asking for a $2,000 surety, Your Honor. No contact with Mr. Ivy. Stay away from wherever he may be. No drugs, alcohol, or weapons, and social worker visit if needed. Thank you.
All right, Ms. McLeod.
Yes,
Attorney-
Your Honor. My client is 62 years old. While she has a fairly extensive arrest history, I did not hear anything recently, certainly not in the past 10 years, Your Honor. She tells me that she is disabled and she is also residentially challenged. So I would ask the court to consider, if not a signature bond for her, certainly as low a bond as possible, because she is certainly not in a position to post bond, and she is elderly and she's also disabled. I would ask the court to take those 2 factors into consideration. She also tells me that she gave the alleged victim some money. He took some money from her to find her accommodation, and he actually took her money. So she was feeling very frustrated. She didn't know what to do because she has very little money, and then he took this money from her. So she was really feeling in a bad place because he was interfering with her ability to have accommodation. And this was what caused the altercation between them. Nothing further, Your Honor.
All right. She certainly obviously probably needs a social worker visit to maybe help with the challenges that she's going through
Yes,
right
Your
now.
Honor.
So I'm going to certainly order that. I think isn't this one of the restricted charges, State?
No, Your Honor, terroristic threats is not a
It's not?
restricted charge. The magistrate who made that list made an error.
Oh, okay. Thank you. All right. I will give her a $4,000 signature bond. If she's disabled, residency challenge, I guess I won't do it through pretrial. Do you have a way to contact her, Ms. McLeod? Do you have some
I
contact?
do, Your Honor. I got her address and an address and a phone number for her
Okay.
that she tells me is a working number.
All right. So I'm going to trust Miss Ruff that you will come back to court and you will be contacted, but at the very least, you will keep up with your attorney, Miss McLeod, okay? So that you will know about your court dates and won't be an FTA to get arrested again, okay? All right. So $4,000 signature bond through the jail. And excuse me, I want you to stay away from that 532 Cleveland Avenue. No further contact with Anthony Ivy. And it says, Ms. Ruff, that you had a gun or you carry a gun. Has that gun been turned into the sheriff's department or confiscated from her? Do we know?
I don't know.
We don't know. What did she say?
I said they confiscated, they took it from me.
They did take it from you? Well, if you have any
Yes,
other
ma'am.
guns, I'm going to order, as of today, if you have any other guns at your home or in your possession, that you turn those over immediately to the sheriff's department as well. You are to have no guns, no drugs, no alcohol, no weapons while on bond. And no further contact with Mr. Ivy. All right. And social worker will hopefully visit you before you get out. And I think that's it.
Thank you, Your Honor.
Mm-hmm.
Thank
All
you.
right.
Number 16, Ms. Willett.
Sixteen is 24 CR 007967E. Ms. Willett, charged with 1 count of battery family violence pretrial.
Oh, by the way, Your Honor,
Yes.
the cross defendant is my client, Terry Smith, number 13.
Okay.
I think that's right.
What? Willett, 2012 battery NOD.
Okay. Just that one.
Yes, Your Honor, that's my understanding as well.
Okay. All right. Go ahead, state.
This is an incident from the 4th of December at about 2:25 in the morning. Police were called to 1134 Welch Street Southwest, excuse me. It's reported that Mrs. Willett and her co-defendant, Mr. Smith, lived together. On scene, Mrs. Willett spoke to the police. She said that a verbal argument ensued between herself and her boyfriend. He ran at her, and the next thing she knew, she was on the ground. She had braids that had been ripped from her head, and there were braids on the scene, both inside and outside the location. She had bald spots as a result of them being ripped from her head. Her father, Mr. Ondinga, I believe, separated the parties. That's what the documents say. I don't have contact information for him. Obviously, I haven't spoken to the other party because they were both arrested, Your Honor. So if you want me to go ahead and talk about the co-defendant, I will, or I can stop there. We're asking for a $2,000 SOB for this young lady. No contact with her co-defendant, Mr. Smith, and no drugs, alcohol, or weapons while on bond. It's alleged that as a result of her behavior during this altercation, she swung her purse and struck Mr. Smith in the face with it. That purse contained a firearm, and he sustained a laceration to his face as a result of being struck with that object. And he is position number 13 on the docket, Your Honor. He's got a more substantial criminal history.
Okay. So the state is recommending the $2,000 signature bond. You have any issues with that, Mr. McLean?
Yeah, check your
Oh,
chat
I'm
for
sorry.
Smith.
That's Miss
This
McLeod.
is my client, Your Honor.
Sorry, Miss McLeod, I'm getting them mixed up.
I don't have an issue with the signature bond, Your Honor. I did want to point out to the court that they actually share 4 minor children ranging in age from the eldest is 10 years old to the youngest one being, I believe, 6 years old. So they're fairly young children. 4. Well,
All right. I will order the $2,000 signature bond through pretrial. And with that signature bond through pretrial, I'm going to order, is it 2 days of anger awareness? I'm going
If you-
to have her at level 1. I'm going to order no drugs, guns, alcohol, or weapons while on bond. And stay away. Well, who lives at Welch Street?
that is her dad's address, Your Honor, but she has given me a different address.
Okay. So I guess I won't say stay away from there because that just sounds like that's where they were at that time. But if her dad lives there, he may be a support system. So I won't have a stay away, but certainly no further contact with the victim, Mr. Smith, or cross defendant. So they are to have no further contact with each other right now. If she allows visitation with the children, it should be precipitated by a third party. They can't even have contact for that. So unless that's worked out, then I guess he won't get visitation. But they are to be two football fields away from each other. And she's not to contact him by social media, phone, or any computer or email. When we mean no further contact, that's what we mean, no further contact of any sort. All right, Miss Willett, or Willett? Okay.
Hey, I put his history in your chat.
Thank you, Your Honor.
All right, thank you. That's it.
And Your Honor, this is position 13, Mr. Terry Smith, the co-defendant.
All right.
And so you just heard the facts, Your Honor, of this incident. The defendant in front of you, Mr. Smith, was just sentenced in June of this year, June the 5th of 2024, to 23 SC 190838 under first offender. Part of his sentence is that he's to have absolutely no contact with any young women under the age of 17. I'm not sure whether the children that he shares with Mrs. Willett are boys or girls, but they were just testified to by Ms. McLeod as all being under the age of 17. It's the state's position that there should be no contact. And so we agree that that should be in place here, Your Honor. We're asking for a $4,000 surety to stay away from Mrs. Willett and wherever she may live, and to stay away from that location where her father lives. No drugs, alcohol, or weapons while on bond. He is in violation of the conditions of the sentence he just pled to. Thank you.
All right. And that's Mr. Terry Smith there at this 24 CR 007965F in courtroom 2. Is that correct?
Repeat that again, Your Honor?
Is that Mr. Terry Smith there in courtroom 2?
That is correct, Your Honor.
Okay. All right. And who's defending Mr. Smith? Is that Mr. McLean?
Just unmuted. Thank you, Your Honor. Yes, I do.
All right, go ahead.
Your Honor, my client is 33. He lives on Janice Drive, so there's no problem on the addresses. He has 10th grade education. He's worked at Amazon for a month or so. He's worked as a security guard for 6 years, a bodyguard for 6 years. He's at a company that works with transportation and large trucks, keeping them maintained and washed. He did that for 3 years. He's worked prior to that at McDonald's and Walmart, so obviously he's quite industrious. He's been in Georgia all his life, and like I said, he's 33. He has plenty of local contacts, got all his address and phone information. He won't be missing court. I would ask the court to give him as low a bond as possible, such as a $1,000 surety bond, if a signature bond is not what the court might be leaning toward. Because we would of course ask for the signature bond, but in lieu thereof, 1,000 surety would save him some money.
Now I'm going to certainly not give him a signature bond based on the allegations here and his history. I'm going to order a $3,000 surety bond. And with that surety bond, we're going to order that he stay away from the co-cross defendant, Ms. Willette. No contact between the two of them, no further contact. They should remain 200 football fields away in all the same conditions that I let her know of. Also, there should be no drug, alcohol, weapons, or guns while on bond. And I believe that's it. Anything else, counsel?
Nothing from the state.
Nothing further.
Okay. All right, that's it.
Next, Your Honor, we're gonna go to position number 8, Mr. Hardeman, Terrion Hardeman.
Okay. This is 24 CR 007962G. Terrion Hardeman, charge of 1 count of theft by taking, pretrial.
4. Last arrest was 2023. Got an open case in Superior Court. Terrorist threat, simple assault. It's 23 CP 220254. Another open case, theft by taking, entering auto. 22 SC 1844646. 2021 entering auto PTI. That's it.
Okay.
Yes, Your Honor, this incident happened in March of 2024. I have that the incident location is 793 Burns Street, Southeast in Atlanta. The victim in this case is Mr. Domenico Spongia. The victim was working as a contractor at the location and he left his cell phone inside of his work truck. When he returned to his truck, the phone was missing and it was later discovered that $1,391 was transferred from his Chime account and sent to a person named Crystal Foster. Officers eventually made contact with Ms. Foster, who stated that her brother, who is the defendant, sent her the money. Officers then spoke with the defendant, who confirmed that he did indeed send his sister the money from the phone. The state's recommendation, given the fact that he has 2 open felony cases, is a $2,000 surety bond, no further contact with the victim, Domenico Spongia, stay away from the incident location, no drugs, weapons, or alcohol while out on bond. And I would ask the court to sound for the victim, Mr. Spongia.
Mr. Spongia. Mr. Spongia. Nope. All right, PDs.
Yes, Your Honor, my client is 21 years old. He has lived in Georgia all his life. He's a graduate of Maynard Jackson High School. I don't know what, I don't think he has any convictions. I don't know, the 2021 PTI, but he does have open cases. I don't think he has any FTAs ever. So he's not a flight risk. He's lived here all his life. He's not going anywhere. He does deny the allegations as stated in the warrant. Let me see. And Your Honor, Because of his limited criminal history and no convictions, no FTAs, I would ask for a signature bond through the jail in this case. He is working in as a landscaper and says that he makes very little money and he's afraid he'll lose his job if he's in jail any longer.
Okay. I'm going to order a $2,000 surety bond. Excuse me. $2,000 surety bond. I'm going to order that he stay away from the what is it, 793? Was it Burn Street?
Yes, 793 Burn Street. Burn is BERNE.
Oh, BERN. All right. Stay away from that location. Have no further contact with Domenico Spongia, the victim. Also, no drugs, alcohol, weapons, or guns while on bond. And I think that is it.
Next, Your Honor, is gonna be position number 3, Mr. DeAndre Anderson.
Okay. This is 24 CR 007957A. DeAndre Anderson, charged with 1 count of theft by taking, pretrial.
28. On probation for ag assault strangulation. Got an open criminal damage to property. 2nd degree, 24 SC 004421. Last arrest was in July for robbery. That was dismissed. I think he been in custody since July. I don't know. Simple battery shoplifting that's open. Got a 2024 battery shoplifting conviction. 2024, 2023 probations. 2023 possession of drug-related objects, shoplifting, and giving false name conviction. 2022 theft by receiving conviction. 2020 trespass conviction. 2019 possession of tools, trespass conviction. And a 2015 battery DB, obstruction, fleeing, reckless conduct, first offender. That's
Okay.
Yes, Your Honor, this incident happened yesterday. The incident location is 944 South Central Avenue in Hapeville. The defendant is accused of taking a bicycle, which is the property of Hapeville Public Works, from the incident location. Officers observed the defendant, who matched the description of the individual who stole the bike, riding the bicycle, and detained him. While officers were transporting him, he stated to officers that it's just a misdemeanor theft. I don't care. He currently has a $600 surety bond. We would ask that at the very least that remain the same, if not be increased, given his criminal history and open cases. We do not believe he qualifies for a signature bond. Stay away from that incident location and no drugs, weapons, or alcohol while out on bond.
And what was the amount again?
He currently has a $600 surety bond.
And the state was recommending?
Honestly, it needs to be increased, I think, to at least $1,000 given his history and his open case.
Okay. All right. PD Atai?
Yes, Your Honor. My client is 40 years old. He has lived in Georgia all his life. He's a high school graduate. He does have minor children. I don't think that having an open case is a reason to increase the bond or disqualify him from getting a signature bond. It's a theft by taking a bicycle. He does deny the allegations as stated in the warrant. I don't think he has any FTAs. He's not a flight risk. He will return to court. I would ask for a signature bond, even if it's through pretrial services. At level 3, he's currently not working. So even a $600 bond, which he has right now, is like no bond at all for him. So I would ask for a signature bond through pretrial services at level 3, or the least for the bond to remain at the $600, although there's not much of a difference for him between 600 and 1,000.
And the state's recommendation isn't based just on his open case. It's the fact that he has 28 arrest cycles and he also has a felony conviction on his record.
All right, I will order a $500 surety bond. And with that $500 surety bond, stay away from 944 South Central Avenue, I believe it is in Hapeville. No further contact with any of the employees there at the Hapeville location. But he will be staying away from there. No drugs, alcohol, weapons, or guns while on bond. So 500 surety. Next.
Next is gonna be position number 4, Mr. Terrell Brown.
'24 CR 007958G, Terrell Brown. Charged with 1 count of false report of a crime. Retrial.
Second. He's on probation for DUI as of June, out of the cab. That's it.
Okay.
Your Honor, this incident occurred October 3rd of 2024. The defendant is accused of falsely reporting that his vehicle was stolen after it was involved in a hit and run. Officers used cell phone analysis and video footage to determine that the defendant was driving his vehicle at the time of the incident and that the vehicle had not in fact been stolen. The defendant did have a suspended license because of that DUI, which is probably why he said that the vehicle was stolen and did not stop at the scene of the alleged incident. The state's recommendation is a signature bond, no driving without a proper license and proper documentation, no drugs, weapons, or alcohol while out on bond.
All right.
Your Honor, I have
Your time.
no objections. I would ask for the signature bond to be through the jail. He does deny the allegations as stated in the warrant. He has a 7-year-old child, is a Georgia resident, and he does work full-time and doesn't want to lose his job. He is a kitchen supervisor at a nursing home. So I would ask that this is his second arrest and he's 36 years old. So I would ask for a signature bond through the jail.
Okay. I will order a $1,000 signature bond through the jail. I will order no drugs, alcohol, weapons, or guns while on bond. I will order him, I guess, to stay away. Where's the stay? Do we have a stay away location? Yes.
No stay away location, Your Honor.
I'm sorry.
There's no stay away location.
And were there any other conditions the state recommended? None?
Just no driving without a valid license and proper documentation.
Gotcha. And so no driving without a valid license or proper documentation. And that'll be it.
Next one is gonna be position number 6, Mr. Blake Dyer.
Okay.
Yeah, what was that bond?
1,000 SOB jail.
Thank you.
This is 24 CR 007960F. Blake Dyer, charge of 1 count of theft by taking.
8.
Retrial.
Appear to have open case out of Tennessee, ag assault DV. Open vandalism, malicious mischief, ag burglary, ag assault, interference with emergency phone call. He's all out of Tennessee. Assault on law enforcement officer, criminal impersonation, 2018 vandalism conviction, 2018 ag assault. That's it.
Okay.
Your Honor, I have that this incident occurred at 5111 Pine Heights Drive Northeast in Atlanta. The victim in this case is Jeffrey Lalo. The defendant is accused of stealing the victim's package, which contained a Bose speaker. The theft was caught on the victim's Ring camera. The courtesy officer at the location stated that he had gotten some other calls about packages being stolen from other units, and they were able to trace down the defendant, who confirmed that it was him in the photo of the theft. He currently has a $600 surety bond. We believe that bond is appropriate, so we ask that it remain the same. No further contact with the victim, Jeffrey Lalo, that is Lalo, and then stay away from the incident location. No drugs, weapons, or alcohol while out on bond.
So he doesn't live there. Correct.
It looks like it's an apartment building, and the victim lives at 5111 Pine Heights. I don't know if the defendant lives in a different apartment building. I'm not sure.
Okay, let's see what his attorney says.
Your Honor, I would have to look back at the booking sheet. I just got his phone number, but I know he is living in Atlanta. So it may be the same apartment complex.
Well, I'd like to ask him.
Your Honor, I'm staying with a friend there at that location. Yes, apartment 5101.
Okay, but you don't reside, you were staying with the friend, but you don't reside there now?
Well, that's the only place I have to reside right now, yes.
Okay.
So he's living with that friend. So it is the same apartment complex. Your Honor, my client is 39 years old. He has lived in Georgia all his life. He graduated from high school in Dalton, Georgia, and attended Dalton State College, where he earned his bachelor's degree. He did recently lose his job at Kroger, working in the meat department, so he does not have any money. He cannot afford a bond. His bond is set right now at $600. I think the pretrial report states that he is recommended for a UJR at level 2. It's not a bail restricted offense. I think he has one prior misdemeanor conviction. I would ask for a signature bond, even if it's through pretrial services, so that he can, because with a $600 bond, he will not be able to get out. He does have a dog that his friend is taking care of right now, and he's worried that that dog will be taken to a shelter or a pound if he can't get out to take care of it. And he does deny the allegations as stated in the warrant. He's charged with one count of theft by taking. I know there was a mention of other packages being stolen, but he's only charged with one count of theft by taking, and he does deny those allegations.
Well, you know, with the challenges he has, I guess my biggest question again is reaching him and for him to be able to
well, he does have a good phone number, which I got from him, and he's not residentially challenged, but he's living with a friend in Atlanta.
well, I'm going to order that he not go back to live there, obviously. He's gonna have to find somewhere else to go. Just trying to think about the bond.
Your Honor, I saw that he was recommended for a signature bond at level 2. It's not bail restricted, so I think that he does qualify for a signature bond through pretrial services.
Can you take him pretrial?
If you order it, I guess. I mean, it's up to you. You know, it's always up to you. I don't care what no recommendations say.
I know, right?
They can repeat it 1,000 times. It's up to you. It's your bond.
Right. Yeah. I will, did I hear in his history though, an ag burglary and assault? When was that?
I believe it was from 2018.
Oh, 2018. Okay. Okay. All right. I will give him $1,000 signature bond through pretrial at level 2. And I'm going to order that he have no further contact with Jeffrey, and is it Lalo? Lall?
Yes.
And he stay away from the Pine Heights apartment complex, the whole complex. Stay away from there. Just needs to find somewhere else to go live, because obviously he doesn't appreciate living there. because we can't have packages alleged to be taken by him. So, you know, if he needs a social worker visit, do that. Maybe they can help him find a job. No drugs, alcohol, weapons, or guns while on bond. But no further contact with Mr. Lalo and to stay away from the complex. I'm assuming it's called Pine Heights. It may be called something else. But he knows what that whole complex is. So I want him to stay away while he's on bond.
And you better make sure you show the pretrial. Otherwise, you get to go back to Rice Street.
Your Honor, and he will need, I think, a one-time escort to get his things and his dog.
Okay, one-time law enforcement escort to go back to that 5111 location with a police escort, Mr. Blake only, Mr. Dyer, to get your dog and your personal belongings. So you've got to arrange that when you get out. Don't go back alone, else you could be arrested, okay?
Thank you.
All right, you're welcome.
Next, Your Honor, is going to be position number 11, Mr. Harlea Robinson.
This is 24 CR 007970A. Robinson, charged with 2 counts of battery. Pre-trial.
11, 2016 battery conviction, 2012 probation, 2011 possession of marijuana, felony possession conviction. That's it.
All right, state.
Thank you, Your Honor. This is an incident from October the 6th of this year. Police were called at about an incident that happened at 3 in the morning. The report was actually made the following day. The victim in this case in the documents is named Cherry Gary, Cherry Gary. We have tried to get in touch with her today, but have not been successful yet. She reported to the police that she had gone to the location 3767 Wisteria Lane, which is where the defendant was. He had called asking her to bring him some drugs. She went to the location and he was outside waiting for her. She pulled up in her car and he came and got in the passenger seat. He then reached over and began striking her. He bit her on the right arm. She was seen to have a laceration to the area above her right eye and a bite mark on her upper right arm area. She said that she hadn't reported the incident immediately because she'd been drinking and she was kind of in shock. This was at about 3 in the morning. She went home and went to bed, and when she woke up, she made the police report. She showed police text messages being sent to her by the defendant asking her if she was okay and apologizing. She'd reported that she'd had a long-term relationship with the defendant, had known him for a long period of time, and that this had been one of multiple incidences of violence in the past, Your Honor. We're asking for a $2,000 SOB through pretrial. It looks like the last arrest is 2016, Your Honor. We'd ask for no contact with the victim in this case, Mrs. Gary, and no drugs, alcohol, or weapons. The location is, I believe, the defendant's house. Thank you.
All right. PD Atai? No. PD McLean.
No objection.
All right, I ordered that $2,000 signature bond through pretrial. Level 1. And it's 1,000 on each of the battery counts. No further contact with Miss Gary. Stay away from the 3767 Wisteria Lane. No drugs, alcohol, weapons, or guns while on bond.
Your Honor, I believe they say that's his address.
Oh, I'm sorry.
Mr. McLean, is that your client's address?
He lives a little way, so he could stay away from anywhere y'all particularly want him to.
Okay, so stay away from the Wisteria Lane. All right.
Thank you.
Is that
And what is,
staying away from Wisteria? Mr. Robinson, staying away from Wisteria is no problem for you, I take it.
No, sir, and not.
Okay. All right.
Your Honor, what was that address again?
3767.
Wisteria Lane.
Yes, they may have to spell that for you. I don't know.
I got
All right.
Thank you.
Next, Your Honor, is going to be position number 17, Mr. Philip Williams.
Okay. This is 24 CR 007968H. Philip Williams charged with 1 count of battery family violence. No, and I'm sorry, 1 count of battery family violence, the 2nd count of simple battery family violence, pretrial.
Your
Your
I didn't do
Honor,
his. Hold
Huh?
on.
I'm
there's
sorry,
also a reckless conduct on the,
was that NOD, the reckless conduct, or no?
No,
it
Your
says
Honor, there are 3 counts.
There are 3.
counts.
Oh, I see. I'm sorry, it went on to another page. There are 3 charges and reckless conduct is the other.
Yeah.
Okay.
The criminal history for this defendant that I have is that this is his first arrest in Georgia. He has 2 felony convictions out of Florida, Your Honor. Felony drug possession with intent to distribute, and then fleeing and obstruction felony conviction.
What year are those?
2008, no, 2005 and 2006. This is an incident from December the 4th. So yesterday at about 9:50 p.m., police were flagged down by the victim in this case. Her name is Zierra Miller, Zierra. She was in the area of 590 Ponce de Leon. She had visible injuries to her hands. She had broken fingernails. She had damage to the bottom of her pants and her shoes, and grass stains and dirt on her clothing. She reported that while she had been in a vehicle, actually her vehicle, with the defendant where they live in the vehicle, he had been upset with her because she was giving other people too much energy. He struck her in the face and then shoved her out of the moving vehicle there on Ponce. She described the red Camry that he was driving, and while she was speaking to police on scene, she was able to point out the defendant who was driving nearby without his headlights on. She said that he had been repeatedly calling her and following her. She did a positive ID of the defendant, Your Honor. We spoke with Mrs. Miller today. She's on the Zoom. She says that the defendant and she had been in a relationship and were both sleeping and living in that car. They don't share any children. She said this is not the first instance of abuse. She's called the defendant multiple times in called the police, multiple times in different states, but this is the first time he's been arrested. She is very concerned. He's going to come try to find her when he gets released from jail. She also said she's got a tracker on her phone and she's not sure how to remove it, and that the defendant follows her everywhere. She expressed being fearful and requests no contact. Based on the alarming facts in this case, Your Honor, we're asking for a $6,000 surety. That's $2,000 on each of the counts. No contact with this victim whatsoever, and no drugs, alcohol, or weapons while on bond. And if you would sound for Mrs. Miller.
Miss Miller? Miss Zierra Miller, do you wish to address the court today?
I'm here. I just don't know how to work
Hold
this at all.
Oh, okay. Well, I have to be able to see you in order to get on. Do you see the camera button? Red or something?
Yeah,
See
that
see
mean
it up
everyone
there?
can see me in here.
Yep, I can see the top of your head. Move your camera a little bit. Or move back. Okay, gotcha. Where'd you go? Okay. All right. Do you wish to address the court today? Yes or no?
Yes, ma'am.
Raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
The other
Yes,
hand,
ma'am.
the other hand.
Oh, sorry. Yes,
Your right
ma'am.
hand, yes. Thank you.
I do apologize. My mind's been everywhere. I'm sorry.
Okay. All right. And are you in fear of Mr. Williams?
Actually, yes, ma'am. I'm actually kind of more frightened at the fact that I put in the report, so it's like, people like to retaliate and stuff, or you never know who people may know. It's like more so of his family now. Also, like I don't know what he's capable of doing in there and outside of here, because he didn't already show me multiple scenes like that I've had to go through.
Okay. Well, you definitely deserve to be safe. And I'm assuming that means you don't want any further contact with him right now. Is that correct?
No, ma'am. Yes, ma'am.
Okay. Do you all have children together? I think I know the answer. No children together?
No, ma'am.
Okay. All right. You have your car back?
No, I have the car, but I informed the police that I'm dropping it off to his auntie's house, so that way, this is the car that he's used to driving in also. So it's like everybody knows this car. It's just more safer for me to just drop it off to his auntie. So I just literally actually just did that. So I'm sitting with my book bag ready to just go, waiting for a lift.
Whose name is the car in?
It's in one of his friends, actually.
Okay. Not your name.
Yes, ma'am.
Okay. No, it's not in your name.
No, it's not.
Okay. All right. All right. Any cross-examination by the state?
Just one question. Have you had any contact from the defendant and his family since he's been arrested?
Not from either one.
So how did you know to take his car? Did you talk to someone about it?
No, the police officers, they informed me that it was safe for me to take it since I had nowhere to sleep, and we both sleep in the car. They was like, just take it somewhere, and I advise you just park it at a park and get you some rest and drop it at his auntie's house tomorrow. And the
Okay.
lady called me in the morning, informed me that he was having bond at 2 o'clock, so I waited up until
Right.
2 o'clock,
Thank you.
to drop it off.
One question. Hold on.
Okay.
So where are you currently?
Right now, I am currently on the east side.
Are you at his family member's house?
His auntie's, I believe this is Hunter's Pace, Hunter's Trace, whatever.
And you're inside somebody's residence that is a
No,
relative
I'm not.
of his?
No, I'm not in the house. I can't. I'm not allowed in their house. No, no, no.
I'm just asking.
I just
I'm
dropped in nearby. That was all. The
Okay.
keys in there, everything.
And where are you going to be going? Are you homeless?
That's why I was like, it's more so of like I'm scared when he get out if he's gonna try to come for me to send third, because I don't have nowhere to go and I don't have a Georgia ID. So it's really hard to get into a shelter.
Okay. And you've been in contact with our victim advocate today?
Not yet, ma'am. The only person that called me was basically to talk about the case.
That was our victim advocate.
Oh, okay. Yes, ma'am, I did.
Okay, so please reach out to her after this Zoom hearing to get some access to resources, okay?
Yes, ma'am.
Thank you. Thank you.
Thank you so much.
All right. Mr. McLean?
Your Honor, with no children together, there's no reason in the world for him to have any problem with, say, no contact. So he would ask the court to set his bond as low as possible. I do note that attempted something drugs and fleeing to elude was, I don't know, if we were good at math, we wouldn't be lawyers, is the old joke. So 18 years ago, somewhere between 15 and 20 years ago, something like that. And the other case in Georgia, I don't know about, but the major thing seems to be quite some time ago. He's 39 years old, lives in Gingham in Lithonia. He's got a GED education. He drives a truck over the road and it's sometimes a little bit local. Before that, he worked for Instacart. So we would ask the court he's been in Georgia for at least 8 years. And so we would ask the court to consider a signature bond, or if that's not possible, or if it's just not possible at all for several reasons, then we would certainly ask the court to give him a $1,000 bond.
The facts are a little alarming to me, and I want to make sure that the victim is going to be safe and that there's going to be no retribution or no, threats made to her if the defendant were to get out on bond. You can put your hand down, Mr. Williams. It's not your time to speak. This is not your trial. And the fact that it's his first arrest in Georgia, but he has the priors, some of that concerned me as well. So I'm going to order a $3,000 surety bond, which is $1,000 on each of the charges. I'm going to order that he have no further contact with Zaira Miller. He's to stay 200 yards away from her, 2 football fields away. And I'm saying this, that if he does violate that and comes near her, calls her, contacts her, or anything, she is to call the police and he can be rearrested. No drugs, alcohol, weapons, or guns while on bond. Don't contact her by third parties or any other means or mechanisms. No drugs, alcohol, weapons, or guns while on bond. 3,000 surety. Next.
Your Honor, all we have left are the 2 that were needed for breakouts, position number 5, and position number 7.
Okay.
That's the South Annex.
Yeah. Guess we will do those.
Can you please?
You want me to give you the history first?
Yeah, but I guess what we can do, who do we have left here? The rest of the people left are employees?
No, ma'am.
Who are you? Oh,
Oh, that's Ms. Strong that responded, but it's people.
I know. I
people
get
on
ready
here
to
that
say
aren't.
somebody, well, who's that at the South Annex? That's one of the breakout people. Okay. And whose iPhone?
We're parents of one of the defendants.
Parents of whom?
Farley. He's 17. What else?
Did we
I
already?
don't know. No, he's one of the breakouts.
Schofield.
I don't know who Russell and Fawcett is on here.
I'm a new
Curtis
assistant
Schofield, I
solicitor
spoke to
general.
public defender, Mr. Ty, earlier, about 5 minutes ago or so.
Who's
30 minutes
speaking?
ago. Yes, Curtis Cofield. I was added to the list as well.
You were added?
No,
Yeah.
he's
Your
on
Honor,
the
he's
calendar.
position 5 on the calendar.
Well, he's one of the defendants.
Oh, I see. 5. I thought it was 5 and 7. So where did we get a team from?
It is 5 and 7.
7 is the 17-year-old.
7 is 17. Is that what you were saying?
Years old. He's 17 years old.
Yeah.
Thank you. Okay.
How would they finish it?
The defendant should not be talking. All right. And then who's iPhone 150? Because what I wanted to do is
That's
just to
Farley's.
stop.
That's Farley's father.
Who?
That's his father.
Oh, for Mr. Cofield?
No, for
Mr. Farley
position number
London.
7.
For Mr. Farley, that's the iPhone 150. She's saying Tessa Farley is the mother, well, the stepmother, and then Chiquita Brown is the mother for
So
position
I'm
7.
trying to prevent us from having to go in the breakout, but we have relatives. We could take this one first, and then after that, we can stop streaming and just record and not have to do all the breaking out.
There's still other people on here, Judge. I'm not sure who Danielle Russell is.
This
So
a
there are
new
two
lead,
individuals
English G.
There's
Welcome
two
aboard,
individuals
Miss
in my
Russell.
office here, Mrs. Russell and Mrs. Fawcett.
And welcome aboard, Miss Fawcett. They're both observing. And who else? So let's take this case first.
Your Honor, could we stop the YouTube for both of these?
Yes, for both.